Perfect. Now I can hear myself extra loud. Good morning. My name is Gretchyn Meinken, and this is Elizabeth Crego, and we're here to talk to you about estate planning. It's the essential documents for aging well. Liz is going to start this off. And just as you heard before, please hold your questions until the break, and you can come find one of us at our tables. Liz's table is over here, my table is over there, and there are lots of other estate planning attorneys here who can answer your questions.
Thanks, Gretchyn. Okay, so we're going to start off with talking about the essential documents that you need to plan. These are both documents that plan for after you die, but also, maybe more importantly, the documents that you can plan for getting through the rest of your life in the best way possible. So, okay, next slide. All right, so when should you plan? And I would always say, right now. There's no time like the present. It's best to plan when you are able to really think through these things, to be able to, when you have the capacity to do that. And by capacity, we mean, everything is still working the way that it's supposed to. You haven't been diagnosed with any kind of degenerative mental condition yet. We hope that we live as long as possible without that. But it does happen, and you want to be able to do this before things are really necessary. If you do have documents in place, it's a great time to kind of review them, make sure that they still reflect what you want to have happen. If you don't have anything in place, then definitely get it done. Because again, once you get into the weeds of things, once you end up declining and everything, you have diminished capacity, your ability to get these documents done is going to be a lot harder. Next slide. So you may be thinking, wow, I should have planned for this years ago, or maybe it's too late, or maybe mom should have planned for this years ago and now it's too late. You can still plan even when you are facing those health issues, even when you are getting to that point. I often have people coming to my office that have diminished capacity, and we have to make an assessment of whether or not they are able to do those documents. And sometimes they can't. Even when you have dementia, there may be times of the day that you are more able to understand things, and we can work with you on that. So capacity is the ability to understand and execute legal documents. And again, it may be an issue if you wait too long. Your attorney needs to be comfortable with your level of capacity. And so that means that I will take you, or if you're bringing, a friend or family member that you want to have get these done, we will take whoever's going to be doing those documents apart from their family members and friends, just to make sure we have a conversation with them. That conversation is so that we can assess their capacity, make sure that they understand what's going on, they understand what they're doing in our office, and also so that we can make sure that they know what they want, and that they are able to express that to us. And that is necessary to be separate from loved ones, because loved ones can often interfere. If you have a friend that's having difficulty expressing themselves, you want to jump in. We want to make sure they can jump in for themselves. And so that's really important.
And they may be asked to leave the room.
Yes.
Just that way the attorney can have a one-on-one conversation. It's not intended to be an insult. It's not intended to be slight. It's just that way we have to do our own due diligence to make sure that you know what you're doing. That's all.
Right. I'll often have somebody come in, and I'll say, can you step outside? And then when I've gone through things with that person, I can say, okay, well, we can have your friends come in so that we can find these now. It's possible to, and there's a little bit of a distinction. When you're doing a will, testamentary capacity is kind of this low bar. It requires the attorney to know that you can identify your family members, explain the types of assets and amounts, understand what a will does. Anything else, powers of attorney, advanced medical directives, which we'll get into in a little bit, require a little bit more capacity. So if you don't have the capacity to do a will, you don't have the capacity to do any documents. And so again, that's really important to do that when you're able to understand them. Next slide. So the documents we're looking at, and that we'll focus on here, are specifically an advanced medical directive, A general durable power of attorney, those are the documents that are dealing with what's going to happen with you through the rest of your life, okay? And last will and testament is something that deals with what's going to happen with things after you die. And also, Gretchyn will be talking about revocable trusts. That's also a document that can be recommended for a lot of people. Next slide. All right, so we're going to talk about general durable powers of attorney. A general durable power of attorney outlines you can make financial and business decisions on your behalf with regards to assets in your name, okay? And so that's going to be somebody that can maybe enter into a lease agreement for you, contract with an attorney for you, they can pay your bills, they can talk to the bank, they can do those kinds of things, okay? They are supposed to be a fiduciary that acts in your interest. This is not somebody that's going to be taking over and doing what they want to have you do. They're not going to try to control you. You should be choosing somebody that you trust to act and do what you would want to have done.
And that is fiscally responsible.
Yes, that's a fiduciary duty. Typically, when we sign this, most of the time you're signing it when you still have capacity, and it goes into effect right away, so that they can start acting right away in your name, and then it lasts no matter what happens with you, unless you decide that you want to revoke it, it'll last through the end of your life, okay? Sometimes people are concerned, they say, oh, I don't want this person being able to do things right away, I can do this for myself. I will hesitate to say that it is possible to draft the document so that it only becomes effective when you lose capacity. However, that's not recommended. Why? First of all, isn't it better to have somebody acting when you can, kind of watch what they're doing? You don't want to have, if you don't trust somebody to act when you're able to act, why would you trust them to act when you can't fix it? Second of all, if you lose the capacity, so let's say you get into a car accident, you're in a coma, you have a bill that's due the very next day. What needs to happen is there needs to be a writing from a doctor saying that now this document is effective for you to be able to pay that bill, and there may be a lag time. So the idea that it's available right away really makes everything.
And I'm going to chime in here and give you an example. So I have a woman who, she was not my client. She ended up having a capacity incident. She was in the hospital, and her agent under her power of attorney needed to access her financial accounts to set her up for a rehab facility and then a long-term care facility. She went to the bank with her springing power of attorney, meaning one that doesn't take effect until you have a capacity incident, and the bank refused to accept it because she didn't have valid proof that the woman lacked capacity. So her next step was she came to me. The agent of the power of attorney came to me, and I then had to write a nasty letter to the bank threatening to sue them because they were in breach of the statutes. And we got all the doctors to write paperwork saying that she lacked capacity, sent that in. And within a business day, miraculously, the power of attorney was accepted. Now, so I say this because she then had to waste time hiring an attorney to help her and spent money on me to help her that was totally unnecessary if she just had a durable power of attorney. So that is an example of what happens, and that was just 3 years ago. Okay, so this is a regular thing. The banks are very concerned about powers of attorney, and so if they see a springing one, they're going to make life very difficult for your agent.
Yeah, banks can be difficult even with the best drafted power of attorney. Sometimes you really gotta be nasty with that. But it's exactly what Gretchyn said. You don't want to make it even more difficult for things to happen. Moving on to our next document, which is the Advanced Medical Directive. So advanced medical, a general durable power of attorney, again, deals with financial and personal day-to-day things. An advanced medical directive deals only with medical decisions, okay? We've got, this medical, it can be known as a medical power of attorney or healthcare declaration. And those are really two different parts of an advanced medical directive, or they can be two separate documents. The medical power of attorney designates an agent similar to a general power of attorney, but this agent is going to be the one that is designated to make medical decisions on your behalf. And this agent unlike the general power of attorney, which becomes effective right when you sign it, the medical power of attorney cannot, by law, be effective until two doctors have determined that you do not have capacity to make decisions. That means that you're not able to understand the medical situation that you're in, you're not able to communicate the decisions that you want to make, and the doctors have determined that they need somebody else to weigh in, okay? A healthcare declaration is also known as a living will, more popularly, and it addresses preferences on life support or other health treatment when you have a terminal condition. This document also is not effective unless two doctors have determined that you lack capacity to make those decisions and make those calls for yourself. In addition, the healthcare declaration is not effective unless you've been diagnosed with a terminal condition. So all of those things need to be in place. A terminal condition is a condition from which you are not reasonably expected to recover, okay? And so why is this necessary? Because doctors have an obligation to keep you alive. And they need legal documentation or you saying, I don't want to have this, to be able to withhold care from you, okay? I would say, for me personally, I think the medical power of attorney is probably the more important one to have in place because then your agent has the ability to make all these decisions for you. The living will can strengthen that in that it kind of takes the burden out of your agent's hands to make those critical decisions about the end of your life, okay? And, because if you have an agent, and even if they know, or maybe you've communicated with them, I don't really want to have this happen, and this is your son, and they're sitting there and they're talking about pulling the plug for mom, it can be a hard decision to make, but then if you have that already documented and in place, it makes it a lot easier, things go more smoothly, and you know that your wishes are going to be respected.
And I'll tell you from my perspective on advanced medical directives, I prefer the one document, the advanced medical directive, with both of these two issues embedded within it, the medical power of attorney and the living will. And I say that because the last thing we want to do is shuffle around trying to find a second document about medical. I also say that because there's oftentimes confusion between the term living will and last will and testament. Why people decided to name it a living will, I couldn't tell you, but it's given me a lot of pause because people think they have a last will and testament when they have a living will and vice versa. So from my perspective on drafting, I'd rather have the advanced medical directive and have it called that with everything in your medical under one document. That is really up to your drafting attorney, but that is typically how I do.
Our office does two different documents. We'll review that, and sometimes I wonder if that's the best way to do things, but for now, that's the way that our office does them. All right. Okay, so what happens if for some reason you get to that critical point where you're in an emergency situation and you haven't planned? It's not necessarily the end of the world. Again, we're here because we're saying that it's better if you have, okay? If you do not have an advanced medical directive, and I think the previous presentation touched on this a little bit, there is the Virginia Healthcare Decisions Act, which designates who can make decisions, medical decisions for you. And it's based off of your closest living relative. So if you have a spouse, easy call, it's going to be your spouse. If you have a child, it's going to be that child. If you have 6 children, like my husband's family, his father had 6 children when he was hospitalized, it was basically like, oh, who's making decisions for dad here? And that can get a little bit dicey. But if it's a clear example and everybody's on the same page, then there is a way to have those decisions made. If you don't have a financial power of attorney, but you have joint bank accounts or authorized users on those bank accounts, and you don't have too many assets, then you might be able to get by. If your only income is through Social Security and you have a representative payee, also you may be able to get by. And other situations, or if you have a trust and that deals with things in during your life, that is also a really good way to do things apart from powers of attorney and advanced medical directives and in conjunction with them. Otherwise, if you have not planned, you may be facing a guardianship or conservatorship. And that's kind of, the scenario that might happen. So what is a guardianship and conservatorship? It is a legal proceeding. Oh, if we could get to the next slide. Yeah, thank you. It's a legal proceeding to declare you legally incapacitated and to put somebody in your stead to make decisions for you. Okay? It basically takes away your rights. You lose the right to drive, you lose the right to vote, the right to marry, the right to possess a firearm. The judge may have some discretion over some of these. I will say that most of the time, if you lost the right to drive and lost the right to possess a firearm, they usually don't allow people that have been declared incapacitated to have those. I have seen them allow them to have the right to vote, though. And so,
But that's in the judge's discretion, and
the
not all
judge's
judges are going to let you have that right.
and so and it's not up to you anymore. And I think that's the key. It can be expensive. So, we've noted here that it's about 7 to 10K for hiring an attorney and getting this whole entire thing done. I do nonprofit law. We do handle guardianships. We don't charge legal fees for it. You still have to pay for filing it. You still have to pay the guardian ad litem. There's still filing fees for annual reports that you have to do. It is definitely not the less expensive option between that and a power of attorney or advance medical directive. The guardian, and so in Virginia we have guardianship and conservatorship. Guardianship is over medical decisions and personal day-to-day things. A conservator would be over your financial decisions and management. You don't have a say if you've gotten to this point over who's appointed as your guardian or conservator. Now, if you've done an advanced medical directive or power of attorney in the past, and for some reason there's a gap in that document and it's determined that you need a guardianship to kind of cover that gap, those documents will usually govern, they'll heavily weigh your preference of the agent in that document. But most of the time, you're kind of at the whim of whoever has decided to file that for you. It can be a family member, it can be a friend, or an attorney, or possibly a city agency or something like that. And it generally lasts the rest of your life. Now, we've presented this as kind of a scary option, and there has been a lot of, like there's movies, there's news about guardians that abuse and take advantage of their, the incapacitated person. When I deal with these in my office, I will say that it is always a loving family member who wants to do this because they want to take care of mom or dad, or they want to take care of a child that has had an accident or something like that. And it can be a mechanism for getting you good care in the event that you haven't planned. So it can be a positive thing, but it is something that you want to avoid if you can by planning ahead.
All right, so I'm going to take over now on wills and trusts, and we're going to talk about them side by side. Thank you, Marcia. So a last will and testament. I think all of you probably have a pretty good idea what this is, but I'm going to go ahead and say it. This is the document that dictates basically who's responsible for winding down your affairs. We call them your executor. So when you pass away, you have a last will and testament. If you have assets that are governed by it, and those are assets that aren't held jointly or don't have beneficiary designations, your executor's job is to gather those assets, pay your debts, and distribute what remains pursuant to the terms of that will. If you have a trust in addition to your will, so if you have a trust, you are still going to have a will, but your will is going to say, I leave everything to my trust. In that case, then the trust is going to do the work about who inherits what when you pass. So they work you can have a simple will, or you can have a will and trust combination. It just depends on your circumstances. But both your trustee and your executor are going to wind down your affairs. So they're going to gather the assets, pay your debts, and distribute what remains as you dictated in the documents themselves. Next slide. So the will, we just kind of went through some of the basics of what it does. It also can do things like detail your preferences on cremation, burial, if you have funeral plots, or you have other preferences in terms of where you want your ashes scattered. It can name, if you have minor children, or disabled children. It can also involve guardianship recommendations for those persons. And I'm going to preface this with, your will governs only what we call probate assets. Those are your assets in your sole name that do not have a beneficiary designation, right? Next slide. So how is it created? Well, preferably you went to an attorney to have it done, as opposed to doing one online. And I say that because while the online system seems easy and it's obviously free or almost free, what we find is that even with the companies that are doing these, that offer these programs, the underlying documents are in fact drafted, I believe, by attorneys, the paragraphs and provisions, but what you're not getting is somebody who actually is helping you put them all together. And so we have seen this multiple times in the past few years where someone went online, did an online will, and then tweaked the terms based on what they thought was appropriate. And while that may make sense to a layperson, it doesn't work in terms of the law. And so those have all ended up in litigation, which is a lot more expensive than if you just paid an attorney to do it correctly, or if you've gone to legal services and had it done correctly. So yes, those tools are available to every single person in this room, but I strongly recommend you not go that path and just ask the professional for help.
Just as an example, I recently had someone come to my office who had gotten these things done online and brought them for me to review. Every single one of the documents had problems with them. And the Advanced Medical Directive had a signature page that named it as a will. They had, one of them had been notarized on a different date than it had been signed, which is an absolute no-no. It was just, every single one of them, I could find a reason why that could be challenged in court. And so it's not just the substance of the documents that Gretchyn said, it's also the way that you're signing them and the formalities. And those are the most important things, because when you're going to put that will in probate or try to use it to enforce something, you want to make sure that they can't challenge it, that they can't look at it and say, well, it looks like this wasn't signed by you or something like that.
So your will, so created preferably by an attorney. You are the testator, so you're the one creating this will, and then we're going to need two witnesses over the age of 18 who are mentally competent. You're going to sign in front of the witnesses, they're going to sign in front of you, and the notary's going to watch all of you collectively signing everything. So it's a very formal process. Most attorneys will have witnesses on staff, so you don't need to bring anybody, just yourselves. And then the other document we always put on is a self-proving affidavit. And what this just says is that all the formalities were complied with, that you were over the age of 18, you did this at your own permission, you told everybody this is your will, these are your intentions, the witnesses saw you, you told them all of these things, they've all signed, and so that documents help us to avoid having to locate your witnesses after the fact and bring them, get a deposition from them. So this document, the self-proving affidavit, is not required in all jurisdictions. I will tell you, DC and Maryland do not require this, but if you are getting a will done in the DMV area, I don't care if you live in DC or Maryland, you should have this just in case, because we're all so transient moving across borders. Okay.
Yeah, even if it's not required, the self-proving affidavit does exactly what it says. It makes it so that you don't have to have witnesses that maybe were there 20 years ago come and testify that it happened. So
next slide. So pros and cons of a last will and testament versus a revocable trust structure. So if we're going with just a last will and testament, there are pros. It's less expensive to create, can be relatively simple, and partnered with beneficiary designations. This is something your attorney can work with you on. It's a way to, it's possible to avoid probate. And I will tell you, there was a con associated with relying solely on beneficiary designations, and I would say, we talked about earlier, somebody's got to wind down your affairs. So that includes filing your final income tax return and paying any taxes you have due. So somebody has to actually do that for you. And if you've got, let's say you have 5 kids, and you named all 5 kids as beneficiaries on all of your assets. If all 5 of those kids don't get along and aren't all willing to kick money back in to wind down your affairs, then you've got the few good ones who are the ones that are now bearing the brunt of that cost. So this is why we don't, When I make this recommendation, I say it depends on your circumstances and it depends on your family dynamics and who's ultimately inheriting. So can you avoid probate with this structure, with a simple will? Yes, there are downsides. Okay? So it's very much dependent on your own personal circumstances. A con of relying on a simple will. Any assets that are in your sole name without a beneficiary designation are going to go through probate. And I'm going to talk in depth about what probate is in just a little bit, but basically it's a court process, your assets, everything becomes public record, and your executor is going to have to pay court fees and possibly bond fees. They're going to have to administer your estate, which on average in Virginia, you're looking at anywhere from 1.5 to 2.5 years. And they've got to do all the winding down, right? You may not realize how much stuff you have in your house, and our last speaker, I think Heidi mentioned this about the accumulation of military families. I come from a military family, and my parents have been in the same house now since 1997, and I have harped on them repeatedly about getting rid of all the stuff that they have somehow amassed. And I say that because I've actually had to clean out houses for estates. And I call them, when I'm driving home from those houses, I call them to tell them what I discovered that day. And they're fascinated by it. You know, it's very interesting. I find some incredible things, but I don't want to have to do that for my parents. And so during COVID, they went through their attic, which how to amass that much stuff, I don't know. But they cleaned the whole thing out. And they've been going through the house and dealing with stuff. So until you actually start opening all those drawers and those boxes, we had boxes that hadn't been opened since 1997 in the attic. Until you actually start dealing with that stuff, you don't realize what you're leaving for the next generation or your executor to do. So administering an estate isn't just dealing with the court, it's actually dealing with your things, your financials, all of that. So that would be one of the cons of just relying on simple wills, that somebody's still doing all of this work because you may not realize it's going to happen.
I will say that having a simple will is better than having nothing at all.
That is correct.
And for some people, that's really all you need. You know, there are people out there that don't really own a house, that don't have a whole lot of things, you know, don't have a lot of heirs. They just want it to go simply to one person or to two people, and that's going to be fine. You need to kind of look at your situation and just make sure that you are.
And consult with the attorney, because whether you're meeting with me or Liz or any of these other attorneys in here, we're going to ask you what your goals are. What are we looking to accomplish here? What are your assets? We're going to look at the whole picture, and then we're going to give you some options, and you pick the option you're most comfortable with. One of the other cons is if we have any minors inheriting, right? So if you decide you want to leave money to your grandchild, and it's in a simple will, if that child is under the age of 18, we will likely end up with a guardianship of the property for the minor. And that is basically probated every year until they turn 18. So highly undesirable from everyone's perspective. Next slide. So we just talked about simple will. You have pros and cons. It works for a lot of people. It doesn't work for everyone. This one's the same way. So this is a will and a revocable trust. It works for some people, but not for everyone. And that's where you really need to confer with a professional to understand what works best for your situation. When you have a revocable trust, you still have a will. The will is very short and sweet and says, I leave everything in my trust. And the reason why is the trust document is the document that's actually dictating what happens to your assets when you pass. So a trust, I like to say, think of it like an LLC. It's an entity. You are the creator of this entity. You are also the manager of the entity while you're alive and have capacity. So anything you put in there, it's still yours to do with whatever you wish, right? There are no restrictions, it's still you. There are no tax benefits or negatives to doing this because the trust uses your EIN, your social security number. It is your alter ego for IRS purposes. So they do not consider this as anything else. So you can put things into the trust, some things, you can put financial accounts that are not retirement accounts into the trust. You can put real estate into the trust. You can put your things. So all this stuff in my parents' attic, I signed it into their trust. So there are things that, it can hold everything just like you do now. So When we have the trust, our goal is to avoid probate, very much so. And so we want to rely on that will as little as possible. And so that is part of the process that you would have with an attorney to talk about this. And I will tell you, we're talking about trust today because I get a lot of questions at this event afterwards and the breaks about trust, because we don't normally go into it as much. But this way everyone has an understanding of what that is. So the pro of a trust is that you can use it to hold assets now. It makes it a little easier on your successor trustee. So you are your own trustee while you have capacity. You've named your successors after you, and those people, if you have a capacity incident, or you frankly just don't want to deal with any of this anymore, you have somebody else who can step in and manage those assets. For some reason, it's a lot easier for a successor trustee to step in and manage assets than an agent under a power of attorney. Banks and financial institutions, for some reason, are a lot more willing to accept a successor trustee over a power of attorney. You still have a power of attorney when you have trust, because there are assets that can't be in your trust. Your retirement assets cannot be in your trust while you're living. Okay? So you need that power of attorney that we talked about earlier to help manage those assets. So pros that can hold assets makes it a little easier for your successor to step in and help you when needed. It's designed to avoid probate. So in our perfect scenario, we avoid probate entirely. In the most likely scenario, we have a very small probate because of your vehicle. And I think Chris mentioned this earlier, nobody likes to go to the DMV, I don't either. So most people don't put the car into the trust, totally fine with that, I don't blame you. But so long as it's under, I think in July it becomes 70,000. So long as the value of the assets in your name, they don't have a beneficiary under 70, we have a short form process to get your car to the trust when they're gone, okay? And then the administration process can be a lot shorter than in probate. And that's because the court's not involved. Your trust is entirely private. It's not being filed with the court. It is not being publicized anywhere. So your trustee can move a lot more quickly to gather your assets, pay your debts, file your final tax returns and call it a day. Another pro is that we have a lot of clients lately who've been coming in and they're concerned about their children inheriting because they're concerned about potential divorce in the future. So sometimes we use trusts because we want to avoid probate. Sometimes we want to use it because we're concerned about our kids' ability to protect the assets in divorce or from other creditors. Sometimes it's because we have minors inheriting and we don't want the court involved and we don't want them getting money before they're a certain age. And sometimes, we have somebody who has a disability, and if we give them money outright, we're going to cause them to lose their benefits. So we use these trusts to try to protect them while still taking care of them without them actually having control of money. The cons, it's more expensive to create because it takes more time for the attorney to draft it and to help you with the process of funding it and beneficiaries and whatnot. And it can be more complicated. So depending on your circumstances, it could, the language could be a more complicated document than what you would necessarily expect. Next slide.
I would just one note on the bank account situation with trusts, powers of attorney, anything. What I usually advise people is banks can be really particular, and anything you just want to check in with your bank to make sure that you've got whatever they need again before you lose that capacity.
So next slide. What can happen if I fail to plan? We already talked about probate a bit, touched on it. If you don't have a will and you don't have a trust and you have assets in your sole name when you pass, those assets are going to go through what we call intestacy. Meaning we're going up and out the family tree to the next people that are still standing.
Spouse,
yes, spouse, kids, and then
siblings, and which is kind of good.
And I'll tell you, I have a case right now where the court asked me to step in as the successor executor or administrator. And the prior fiduciary didn't do an heir search. He was not related to the woman who passed, knew nothing about her. He got appointed. I was clearly not what he should have been doing because he got removed by the court for a variety of reasons. And one of the problems we had is that he did an heir search on the maternal side and the maternal, but only went 2 levels down. So when I stepped in, I had to find all of the heirs. I have 108 heirs on one side. 108. It made me want to cry when I got the report. It took me hours to digest it. My dining table was covered in paper as I was trying to read through. I mean, I'm talking about up and up and out and out. I've got multiple layers of cousins. These people never even knew this one, and they're inheriting her estate. So spare your children and your family members the pain that I'm going through right now. So that's the intestacy process. And so you ask who would be in charge of your estate in that case. The next of kin gets to, somebody can step forward and serve.
It can also be a creditor.
Yeah,
But the bank can step in and have credit for you.
Somebody who really wants the job can step in. So next slide. Probate. This is what we've been calling it probate. It's in technical terms, the state administration. We all call it probate because it's easier. We already talked about how long it takes on average. It requires court filings with the court. So every single penny that your fiduciary, your executor is managing, every single penny has to be accounted for in the court. So we're typically doing spreadsheets or using software to help track every single thing. So we start with a starting point on the value of the assets when you pass. We show all the money that came in, money that went out, and then what's happened to it. And documentation, literally paperwork showing every single thing. So it's a laborious process. It can be costly, and I don't say it's costly because of the court fees, because honestly, I think those are pretty fair. I think they're fair. Where it gets expensive is, one, if your executor is not a Virginia resident, they have to be bonded by a surety company, so that's an additional premium every year. Doesn't mean they can't serve, just means they have to be bonded. And then if your executor hires an attorney, we do assist people with that work, and I think all of us charge hourly for that work, and so it can really escalate.
Even if you don't, the thing is that the reason why people hire attorneys is because it's a complicated process and you want someone to help you with it. You can do it without an attorney, but again, then you're exchanging that cost in money for a lot of cost in time and headache and that type of thing.
And I should say that when you are dealing with a will in a probate process, your executor is going to take your will to court. It's going to be recorded with the court. They're going to be formally appointed by the court. And at that point, that's where their job really starts, okay? And they are going, if they don't, there are deadlines for everything. If they miss a deadline, they're gonna get a nasty gram from the court. And those are gonna continue until they rectify it. And if they don't rectify it, they're gonna get removed. The next person in line is gonna step in. So it can be, I think for most people, it can be somewhat shocking the amount of time it's gonna take, the amount of the court's involvement. And when you get that first letter from the court, it is scary, I'm not gonna lie. I've been doing this for a long time now, since 2007. And the first time I got a letter from the court, I had heart palpitations. I'm like, we missed a deadline, oh no. And that's me being an attorney, knowing how to do this work. Imagine a layperson getting that letter, right?
No, I think we're attorneys, we tend to try to make things scary because, not try to make things scary, but we like to warn people about all of the possible options and everything. It is possible for you to just have a will, go through probate, not have an attorney. Again, if you've got really simple assets and everything like that, it's the same thing with a power of attorney. You don't want to name somebody that you don't necessarily trust and who doesn't know that they have this responsibility. Make sure that your executor knows what's up. Make sure they're ready to go forward. Make sure you have your stuff in order and they know where to find it and that type of thing.
And tell them you named them as your executor.
Yes. Yes. You don't want that to become a surprise.
I oftentimes have clients who have multiple kids, like, well, I don't want to pick between my kids. I don't want them to think I favored anybody more than the other. This is neither an honor nor a privilege. This is work. It is a second job. And don't be ashamed to tell your kids that this has nothing to do with which of you I prefer more than the other. This is purely who I think has the ability and the time to deal with this. Not every child is equipped to deal with this. Some of them are, honestly, I say, same with the medical power attorney or the advanced medical directive. You want the person named to have the emotional bandwidth to be willing to enact your wishes. So if you've got the really sensitive child in that role, you might want to rethink that. You might want the kid who's like, no problem, I can do this. The same with the financials. You don't want the kid who doesn't really understand how to manage money or gets easily anxious in this role, because it is work, right? And I'll tell you, my dad had to have surgery during COVID. It was a major one, and so literally the night before, we were updating all his documents, which hadn't been done since I was in college. And my brother lives in Texas. He's brilliant. He doesn't do this work. And so I called him and I said, hey, do you mind if we flip the roles? Because he's older, so he was named first on everything. This is totally normal. And I said, would you mind if we flipped it so I'm the one in charge of this stuff? And he was like, oh, thank God, I love you. He's like, I trust you implicitly. You do whatever you need. I was like, yeah, you're welcome. But for us, it made more sense, right? He's not here. He doesn't do this. So that's just, you got to think them through. And whether they're your kids or your siblings or your nieces or nephews, or whoever it is you decide to put in these roles, make sure they are equipped to do the job, and make sure that you tell them you put them in those roles. The next slide, please. Avoiding probate. So we've already kind of touched on some things here. So talked about the trust as an option. Joint ownership with rights of survivorship. This is an option. Now, I'm going to tell you something right now. There's a difference between agent under power of attorney and a joint owner when it comes to your bank accounts. So we only want somebody listed as a joint owner if you actually want them to inherit that asset when you pass, okay?
And you also want them to be able to do something with it right now.
Yes. So when you go, if you go to the bank and you say, I want to add my child on the account, they may presume you mean a joint owner. Understand that that means they now own half of that account. And if they have a creditor issue, that account can be subject to the creditor process. What we would always prefer is that you name them as your power of attorney on that account, meaning they have the ability to access it, to help you, but they own literally zero of it. Okay? If you name them as joint, they inherit that account when you are gone. So if that's the intention, that's perfect. But if that is not the intention, then what you really want is a POA on that account.
And it's okay, if you ask somebody and you absolutely trust them to treat that money as yours, and you know they're financially responsible and everything. We see too many people come in and, they're like, well, my son took all my money, or my son had a lawsuit against him and now my money's being taken and it's garnishment or something like that. And so I just need to be careful with that.
If you can come see us afterwards,
Okay.
that'd be perfect. Yes, we're both over here. The other option would be beneficiary forms is another way to avoid probate. And so all of your financial accounts, every single one of them, and your life insurance policies all have the ability to name a beneficiary. So that is another way to avoid the probate process. And so the next page, sorry. Options for legal assistance. So private attorneys, there are plenty of them here in Old Town, plenty of them in this room. Legal Services of Northern Virginia, that's me, that's Liz. And do you want to talk about?
Yeah, so Legal Services of Northern Virginia, we are a nonprofit law firm, legal aid. We can do the same things that other attorneys can do. We do limit our services so that we can help as many people as possible and help those most in need. That doesn't mean that you can't apply it for some reason if you have a steady salary or something like that. We do have 3 different, main ways of eligibility. One is income, one is over the age of 60, one is disability. And so if you're over the age of 60 or you have a disability, you may not be subject to the same income requirements. But, we don't provide trusts because those are more complicated. We want, again, and it's because we want to help as many people as possible, so we don't get involved in super long litigations or super long processes. We have our information over there at my table. Feel free to come by in the break and get information. What I tell people is the worst that can happen is you apply for our services, we say, oh, we can't help you right now, but we're free to somebody else that can. So.
And then for military retirees, your local JAG offices can actually assist with basic. They don't do trusts, but they can do advanced medical directives, power of attorney, and wills. And I believe that is free to military service members and retirees. So next slide is my information. I'm over there. The next slide is Liz's information. Thank you for hearing us out today. You now get to get up and stretch your legs a bit. I think you've got a 10 to 15 minute break. So enjoy. Go visit all the exhibitors. They all were great to be here.